Hello, welcome back to part three of this week's Law and Ethics lecture about contempt of court. Um, so we've talked about a number of things. We've looked at focused mainly on strict liability contempt. We've looked at the legislation that defines that. We've looked at the basic definitions of strict liability contempt. And we've talked about when proceedings become active and they cease to be active. We've also talked about appeals, how appeals work, how civil cases work in terms of contempt, and we've also looked at how police appeals can still be reported even though proceedings are active. So let's move on to the defences. Do you remember I mentioned at the beginning we need to always think about defences that are available to us as journalists. So let me just move that on. So remembering structuring your thoughts, think about the legislation. So what law is it? So Contempt of Court Act 1981. Think about the definitions. So we've already said is about for strict liability contempt. It's about publishing material which creates a substantial risk of serious prejudice or impediment to active proceedings. So that's an important definition. You then need to know what active proceedings are. So we've talked about that when there's an arrest or a charge or a summons, those sorts of things in the list that we went through. And then I said you need to know about the defences that are available to you. So let's have a think about those defences. So basically there are three key defences. There's what's known as a Section 3 defence. Section 3 under the 1981 Contempt of Court Act, that is. So Section 3 says you didn't know proceedings were active. Section 4, if it's a fair, accurate and contemporaneous report of court proceedings which are published in good faith. Section 5 is a discussion of public affairs. So these are very specific defences, so you can't just use them broadly. You have to meet certain criteria. So first of all, let's have a look at Section 3. So if you use a Section 3 defence, you're saying not knowing proceedings were active. But that sounds a bit weird because I said earlier on that this is a strict liability issue, strict liability contempt, that it doesn't matter what your intent is, that you should get it right no matter what you know. So, but there is a defence on that, but it's a very particular defence that you have to show that you took all reasonable care to show that proper checks were made. So, for instance, if you were reporting on an incident and you wrote a report about that incident, and you checked with the police whether there had been anyone arrested just before you published your story, and the police told you no, there have been no arrests, you could go ahead with that report, and that report might include lots of information because as far as you're concerned there's no arrest. If later on it turns out that there was an arrest at that point and the person you spoke to at the police had misled you or just mistakenly hadn't known that there had been an arrest, and you could prove the time you had rung up and checked, if you could prove that, then you could use a Section 3 defence to show that yes, I tried, I did my best to check whether there was an arrest, whether proceedings were active or not, but the information I was given was incorrect, so therefore that's why I published information I shouldn't have, given that proceedings were active. So it's quite a high test. It can't just be, no one told me. You have to have actively gone out and sought that information. The Section 4 defence, so this is the next defence that's available to us, a fair, accurate and contemporaneous report of court proceedings published in good faith. So this is the absolute bedrock of safe court reporting. So if you ever go to a courtroom and you're reporting on a court case, of course, what you hear in a court is potentially prejudicial, because you have one side saying this person did it and the other person saying no, they didn't. So of course you're going to hear information in there which suggests that somebody is guilty. But what Section 4 of the 1981 Contempt of Court Act says is that you can report what's been said in court, as long as you do it fairly and accurately, and you do it at the time when it's said to it in your first available edition after the hearing, then you're going to be okay. So fair obviously means getting balance into it. It means you can't just report one side of the case, you have to report both sides. You have to get the facts right, you have to get the information right, and you have to do it without malice. You can't show that you've got an axe to grind with one of the people involved. But it's worth just mentioning that there may be automatic reporting restrictions in place. We'll talk about those shortly. The final one, final defence, main defence, the Section 5 defence under the 1981 Contempt of Court Act. So Section 5 discussion of public affairs. Basically, this is saying that you can talk about the general topics that are involved in certain court cases, but you shouldn't talk about the specific court cases. So it's best shown through some examples. So thalidomide was a drug that was given to pregnant women back in the 1960s, and I think it was an anti-sickness drug that was developed and given to people. What they didn't realise until it was too late is it led to a whole series of really serious birth defects in the children. Children were born without limbs or deformed limbs, and this led to a very long-running court case about with the company which made thalidomide. And the Sunday Times wanted to report on this issue of how this drug had caused all these birth defects, but this was suppressed for years and years on the grounds that this is an ongoing court case, that the chemical company, distillers company, was being sued. So therefore, we, as the press, were not allowed to report on the fact that thalidomide had led to birth defects. It took a long-running battle, and as you can see the dates there, right throughout the 70s. It took a long time before the Sunday Times managed to finally win the right to be able to report on this, even though the company was still being sued. So if it's a discussion of public affairs, we can report on it. Another example was this, a doctor, a paediatrician. He was in court accused of murdering a baby with Down syndrome. Reported with sometimes it's called a mercy killing. He was acquitted of it. He was found not guilty of that. But two newspapers report on it. So the Sunday Express, they said that baby died unloved and unwanted, and they were held to be in contempt because by saying that suggested that he was uncaring in what he did and made him appear to be more guilty. The Daily Mail also published an article, but their article really just focused around the whole issue of the right to life. They didn't report on that specific child and that specific doctor, and they successfully used the Section 5 defence. So two different approaches. One, they couldn't defend it because they were talking about the specific court case. One, they were able to defend it using Section 5 because they talked about the issues but not about the specific case. Okay, reporting restrictions. I said we would move on to these. So, remember we talked about the Section 4 defence, a fair, accurate and contemporaneous report of court proceedings published in good faith. Remember that? It's the basic bedrock of safe court reporting. But for this defence to work, you have to observe all automatic reporting restrictions. So there's a range of automatic reporting restrictions that take place in courts. So if there's a preliminary hearing, i.e. summary cases, remember those cases which appear in magistrates' court. So if someone appears in court for the first time at magistrates, it might be a preliminary hearing before the trial takes place. There are basic restrictions on what we can say. Similarly, if someone appears in court in the magistrates and they're going to move on up to the Crown Court, there's restrictions on what we can say. So until the trial starts, we're limited on the amount of information we can report, even though lots of information might be discussed in those court proceedings, because it's not their trial yet. They're trying to prepare for the trial. They're discussing the circumstances of the trial. It's not until we get to the trial that we can fully report what's being said in court. So just be really careful. Don't just think, okay, I'm in court, I'm hearing stuff, I can report it all. You have to ask yourself, is this a preliminary hearing or is it an actual trial? When there are preliminary hearings, there are 7 pieces of information that you are allowed to include. You'll hear some people talk about these as the 10 points, but they've been boiled down a bit over the years. So we can talk about the name of the court and the magistrates' names, give the name, age and home address and the occupation of the accused person. We can report the charge. Now, it's always worth looking at the charge. On the charge sheet, it won't just say murder. It will probably say that he did murder this person on this day in these circumstances. So there's quite a lot of information in a charge. So it's always worth having a look to see what's on the charge sheet, because then you can include all of that, because you can include anything that's in the charge. You can use the name of the lawyers. You can say whether proceedings were adjourned and when and where they were adjourned to, i.e. were they suspended until the next hearing. You can talk about arrangements as to bail. So if someone is bailed, you can report it. However, if someone wasn't bailed, you need to avoid saying that. If they applied for it and they were refused, because that suggests guilt. If a court refuses bail, it suggests that the court regards them as a flight risk, someone who might run away. So you can say whether they were granted bail, but if they weren't granted bail, just leave that out. And you can say whether legal aid was granted or not. That's the 7 things you can say from a preliminary hearing. Until we get to the actual trial of the case, we can't really say anything more. As well as restrictions, there are orders which a court can actually impose on a case. So there's a postponement order, and this is known under the 1981 Contempt of Court Act as a Section 4(2) order. So this is a postponement order. So this is a way that a judge can decide, well, I'm just going to delay certain amounts of information just to try and avoid the risk of prejudice. So if someone is facing a subsequent trial, so sometimes you'll have somebody who's undergoing a trial for one thing, but they may have another trial lined up. So the judge may say, okay, I'm going to place a Section 4(2) postponement order on the outcome of this case until they've then been tried for the second case, so that there's no risk of the second jury finding out that this person has been found guilty and is therefore make it appear that he or she is more likely to have done something else. So they can postpone information, and it can be for as long as the judge decides is necessary. And again, if you breach that, unlimited fine or maybe 2 years in prison. So be careful. There's a Section 11 order. That's a permanent banning order. These are quite unusual, but it basically orders you can never report this particular information. Now I've only seen this in the cases where security services are involved or blackmail victims. They may, in the case of Jean-Charles Menezes, who was a Brazilian who was shot by the police in London on the London Underground because they mistakenly identified him as a terrorist, which he wasn't. There was a Section 11 order placed on the identity of the officers, the undercover officers who shot him, so that they can never be identified as being involved in that case. Commercially sensitive information, if there's something which could be used against a company or used to undermine a company, blackmail, of course, there'd be no point going to court if the information that someone was being blackmailed with then came out through the courts, and national security. So Section 11 order is quite unusual, but that's a permanent banning order. And that's forever. Okay, main thing about court orders is that you need to use common sense, and that's what they mean by good faith. If, for instance, if you're in court and you realise an order should have been made to avoid reporting something when the jury is out, for instance, so if the jury is not in the room and the judge should have made an order to prevent you reporting, it's not good practice to think, oh well, I could get away with this because the judge has forgotten. You should use common sense and good faith to obey the general principles of the Contempt of Court Act. You could flag it up with the clerk of the court and say, I think there should have been an order, am I right, or are we okay to report this? If you do that, you'll develop a reputation as someone who could be trusted and as behaving in a professional manner. There is the chance that if you commit what they call serious misconduct and you basically take the mickey and start reporting things and always looking for loopholes, you could be prosecuted under the Courts Act for what they call serious misconduct, and that can lead to a large fine. So be careful. Okay, I'm going to finish this video here, and before I move on to the last few sections of this lecture.